Bang, bang, and bang. Hey, what's up, everybody? We're live. See a whole bunch of y'all floating up there in the chat. We're talking with a couple of my attorneys real quick about the cases. So I'm letting Mike know we're going to do more bellow first.
Alrighty, gentlemen. If anybody has a court case that they'd like to have heard today, go ahead and come forward and we'll get necessary preparations made.
Yeah, we're doing a motion to quash a subpoena.
Sorry, who's doing a motion
Is
to
this
quash
related
a
to a criminal case or
Sounded
a
like Steve.
traffic violation? Okay, I'm just looking for traffic cases right now.
Oh, that's
if anybody
right.
has a ticket they think was wrong that occurred within the last court cycle. Do you have one, sir?
Yeah, it's for speeding.
You happen to have the citation number?
Yeah, I'm going to look for it.
What case is that? 0042? No. 0041? No.
This would be a 4-6.
Mm-hmm.
942.
Okay.
I should remember my cases better.
What's your name, sir?
Joseph.
Mike,
A.
if that was you, I
Bender.
swear to God, I saw you put condoms in my inventory.
Alrighty. Appreciate it.
Andy, all these sound redemptions are gone. I don't want to have the sound redemptions in my chats. They obliterate them. There's no way. There it is. 0040. What's up, Hash? How you doing? Just so everybody in the chat knows, we're also joined here by Dallas, who's mute and deaf, and we also got Matt here.
Just kind of have you stand by the door for now. Just if anybody else comes in, you know.
No hats in the courtroom, deputy.
Nice hat, though.
Well, actually, technically, they could wear them if they really wanted to, if they're on duty in official capacity, but, like, beyond that, it's, like, not really. You technically really shouldn't. Okay. We can handle more Bella now.
Sweet.
He comes out, we'll figure it out.
This is 9-4. I have one gentleman that came forward with a citation, but it's from July. Should I just let him know it's too old? Affirmative. Copy. I have the citation number. Do you want me to send that somewhere?
What's the postal of the courthouse?
It is 7248.
Sorry, I'm transporting Vlad down there to get picked up by bailiff.
Oh, you're good. I let Mike know we can call the Morbello case. It's not involving you. So, hopefully we can call that one up shortly.
I'm really hoping he don't have anything on him because the bailiff's patting him down right now before taking him down the steps. Imagine if he has like crack from last patrol on him.
Copy.
Oh, I need Valerian in here.
All rise. The San Andreas Superior Court is
All right,
now
so
in
what's the
session.
docket looking like?
The Honorable Judge
Not great.
Rehnquist presiding.
Hang on, we're all rising.
Oh shit. This does not look good.
You'll be okay. Try to coordinate to have.
First
them
case
come
we'll be
back.
hearing is going to be Mr. Morbello versus the state of San Andreas.
Yeah,
Present.
yeah, it's not that exactly. Oh, mother.
May I pass the barrier?
Go ahead, sir.
I do not, sir. Wait. Hang on. Is that my lawyer?
Yeah, Mr. Johnson's the president.
My lawyer is here.
Yes, sir. He's right behind you.
Thank you. I have a lawyer.
All right. And do we have a representative from Burger Shot here?
Who's-
Yes, sir, right here.
Who's the
Do you
flying
want to
fucking
step up as well, sir?
extinguisher?
District
It
Attorney
sounds
there.
like we're just gonna go ahead and have
Oh,
this
okay.
pass rescinded. So this will be nice and quick. We'll get you out of here.
Arthur.
May I come through?
Yes, come on over here
Yes,
for
you
me.
can
Oh,
approach.
okay. All right. What side?
You'll be on this side with me here.
Oh, okay, okay.
You stand right there. So I'm Justin Pearson, the district attorney for Los Angeles County. It sounds like you wanted to just go ahead and rescind that trespass order, right, and allow him back to the burger shots.
All right, Mr.
Oh, yes,
Morbello, I'm
yes.
just
Is
looking
that
at the
Brian?
paperwork here. It looks
And
like
then
this
Mr.
was
Mr.
issued
Crow.
June the 4th at the Burger Shot located in Sandy 3021. Is that correct?
Yes, sir.
All right, so you can address the court as to why you'd like the trespass to be overturned.
I do not believe this was a fair trespass, Your Judgeness. Sorry, Your Honor. It was my friend Chuck who defecated in the parking lot of the Burger Shot. I did not do so. Therefore, I do not believe that I should be restricted from the premises, considering the amazing burger that the Up and Atom generates.
Do you mean the Burger Shot, sir?
Yes.
All right. Have you spoken with anybody from the Burger Shot Corporation?
I called Mr. Kroll. He's standing over there on his personal cell phone. When you're a VIP, you do get their number if you eat more than 300 burgers a year. And he told me that I would be allowed back in because revenues have dropped 31%.
All right. So he told you that?
Yes, sir.
All right, we'll have to hear from him on that in a minute. But what was this you were telling me about your friend doing something on the floor?
Yes, my friend Chuck, he defecated on the floor of the parking lot outside of the Burger Shot. It was not on the inside. I watched, but I did not participate.
All right. If you want to just go back by your attorney there for a minute, we'll hear from the Burger Shot representative.
Hi.
Mr. Kroll, is it?
Yes, sir.
Can step forward.
All right.
All right. Do you want to just briefly explain to the court what led up
Yep.
to this trespass, if you're familiar?
Yes, so Mr. Morbello here behind me. I was advised that he phoned me, left me a voicemail, saying that he was falsely given a trespass by the Los Santos Sheriff's Office, and that he'd like it to be removed. And after reviewing what he was saying, I had to agree. It was his friend, and like he said, he eats a lot from us, and I need him to come back. I need my monies.
All right, Mr. Kroll, you understand as a representative of the property owner, you don't have to have a reason to trespass him. Doesn't matter if his friend did it or not. It's up to you and your company if you want him trespassed.
Yes, from what I heard, that was made by the lower management from me. They did not
Okay,
consult
so
us.
You'd like to formally have that trespass listed?
Yes, sir.
All right, you can go back to the desk there.
All right, thank you.
And Mr. Johnson, is it? Your attorney?
Yeah, Mr. Johnson with a T.
Mr. Johnson, do you have anything you'd like to relay to the court at this time?
No, Your Honor. I think everything's been well put out for you.
All right. If there is nothing further, I will adjudicate the trespass as a void. Thank you, everyone.
Thank you, sir.
Mr. Marbello, if you just get in touch with the clerk on your way out, they'll get you a copy of the order, okay?
Thank you, sir.
Have a good one.
You too. Send me the invoice. I'm going to Burger Shot.
All right, for anyone just tuning in who might not know, as a reminder, I serve as the district attorney for Los Santos County here in SLRP. Tonight is a wonderful court night, and so we are standing in for all of the possible cases.
All right, bailiff, it looks like the next case on the docket here is going to be an in custody. Mr. James Smith, if you can retrieve him.
Of course.
And Mr. Pearson, you know the defense counsel for Mr. Smith here?
My recollection, Your Honor, defendant is currently unrepresented pending arraignment. I believe the two attorneys sitting to my left or right are both court-appointed attorneys available if you'd like to appoint one of them to him. But as I recall, the traffic case he's here on, in addition to that criminal case, he's unrepresented.
All right.
All right.
All right, bailiff, if you want to remove the cuffs, just keep an eye on him.
I'm not gonna do anything.
All right, sir, you are here before the San Andreas Superior Court. State your name for the record.
James Smith.
All right, Mr. Smith, we have a couple matters to deal with for you today, but one of them is going to be a criminal arraignment, so I want to explain a couple things to you first. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney and potentially a court-appointed attorney if your circumstances warrant. Do you understand all that?
I do.
All right, so we're going to deal with the criminal matter first. Before I arraign you, do you wish to have an attorney appointed to represent you?
That would be preferable.
Are you able to afford a private attorney?
I can.
How much money do you make in a month, sir?
We're somewhere right around $500-ish.
Okay. I'm going to find that you are qualifying to have a court-appointed attorney, so that means you're not going to have to pay for it. All right, so just give me a second. We'll get you somebody here.
Whoever he appoints,
Alright.
it's probably one of you three up there. You're gonna come down, and you're going to. Oh my goodness, how am I gonna? Let me send it in our chat here.
I don't know shit about the case, so.
You don't need to. This is a standard thing. I'm gonna send it in the bullpen.
Good.
Mr. Stewart, would you be willing to take on this case?
Yes, Your Honor.
All right, if you want to come forward, I can give you a moment to confer with your client before we start the arraignment.
Over here.
Your Honor, may I request to go somewhere more private to discuss the matter with my client?
Yes, absolutely.
Anywhere you would like us to go, Your Honor?
Deputy, you want to let them into the jury room there?
All right, Dallas, I just sent it. It's kind of a mouthful, but find out. I mean, unless he wants to enter a plea today, I'll craft an offer right now, and I'll just put it on the record. It's up to you guys. Next case up is going to be.
You want to just remind them to be whispering back there?
Next case is going to be Vladimir. You guys ready on Vlad?
Oh, we have a plea, so when they call it, the judge is going to ask for us if we're entering a plea?
Pretty much, yeah. And then I'm going to give my recommendation. And
Awesome.
then
And
All right, we'll be
I'm
in
letting
a
my
brief
client
recess
speak.
while they just get that sorted out.
Oh, I guess
If
you just want to
anybody
do a
needs
recess.
a snack from the lobby, feel free.
I gotta look it up so I can make a reasonable plea offer if they want to go with a plea.
What if Val is... Wait, is Val even here? No.
I don't see him. So that'll be a whole different thing.
Because in reality, Devante's in prison.
Is he still? So that's what you guys are going with? Devontae Smith is in custody?
Yeah, he's in custody. I just don't have him created right
Oh,
now.
okay. Well, in that case,
That's the only drawback.
in that case, what happens sometimes is people in custody will refuse court. They will not go with a deputy. So if Val doesn't show up to do this, we can just say that the information I have is that he refused to come out of his cell, and that we just need to set it over to the next court date, or we can do a special set to have it let out later.
I mean, you could also tell him that he's in solitary confinement.
Yeah, that would work too.
Because refusing is kind of seems a little less aggressive in a sense. Or
Well,
saying
refusing
he's solitary.
Refusing to participate means a lot of things. It can be the things I see in real life. It can be mental illness. It can be they're sick, they're tired. It can be a whole plethora of things. It doesn't mean it's not always like an intentional, like jab at the court. Trying to orchestrate every single aspect of court simultaneously is a little tiring, but very fun.
On the next one, we should ask for a pre-trial meeting with Mike to iron things out.
That would be a really good idea. Trying to go find my probation terms that I sent to Tim a while back. Hey, what's up, Dalton? Luke, I see you, Hammer, Mario, freaking Hash, Noob. I see all y'all there. Sorry, court is very strenuous, so I'm not gonna be engaging with you guys a whole lot tonight. I will try my best.
I can stand up on it.
All right. You had enough time to confer with your lawyer, sir?
I'd say so.
All right. The court will be back in session here. We'll recall criminal case 0108, People versus James Smith. Mr. Smith, today is your arraignment. You have a lawyer now. You have had a chance to confer with him, as you indicated to me, and you still understand your rights, correct?
That is correct.
All right, sir. It is alleged, and you are being charged with burglary in the first degree. That's a felony that carries a penalty of up to 6 years in state prison. Looks like this charge was filed October the 8th by Deputy Haywood. It's alleged in the superseding indictment that deputies found a weapon on your person. That a Deputy Adams filed a probable cause affidavit. In the above case, we'll move on to the probable cause conference once you've had some more time to speak with your attorney. Today is just your arraignment, so I'm going to ask, how would you like to plead?
Not guilty.
All right.
Dallas, you're gonna read
counsel
off
for
what I
defense,
said.
do you want to address the case at all here?
Yeah, stand up and read off what I sent.
Yes, Your Honor. We have received the charging document and waive further reading and advice of rights, reserving all rights under the state and federal constitution, entering a plea of not guilty at the time, and request the next pretrial conference.
That was beautiful.
All right, and we'll hear from the people as to bail.
Thank you, Your Honor. We're looking at an alleged felony burglary here. This is an individual that we don't need to have out and about pre-trial. So in order to keep the public safe, state is recommending a $100,000 bail amount and to have the defendant remanded into custody and not released from today. That being said, we would make an upfront offer if defense would like to reconsider the not guilty plea. Our upfront offer would be for we would do a 6-month prison sentence. Straight time, no probation, no parole, nothing like that. Just 6 months straight custody and have the case closed out.
You talking about amending the charge, or you just want to do a?
No, that would just be our plea offer, Your Honor.
Oh, you wanted to plead out to
In the event they want to enter a guilty or no contest plea, we would recommend 6 months custody.
All right, Mr. Smith and Mr. Stewart, keeping in mind that I have entered a plea of not guilty in this case, would you like to respond to the defense there? Or, excuse me, to the state there?
May I have a second with my client to discuss this? I was not made aware of this pre-hand. I would like to be able to assess this with my client.
Absolutely.
Yeah, sorry about that. That was kind of a last-second thing, Mr. Stewart. I wasn't expecting this case today.
You're fine. Step here.
All things are going beautifully right now. Luke, I don't think we had any cases for you. If we do, we'll call a warrant. I don't know. Well, Mark, I'll keep that in mind next time we see you in court. Have you held in contempt? Mm-hmm.
Your Honor, after discussing with my client, we would like to visit the plea offer on hand that the DA has put forth.
You'd like to accept?
Yes, Your Honor.
All right, Mr. Smith. So we're going to get into this then. Before we do that, I do have a couple questions for you. How are they?
Okay.
How are they treating you in jail there?
Fine, all things considered. Can't complain considering it's jail.
They're giving you all the things you need in terms of basic hygiene and essentials?
Oh yeah, no, I'm getting everything I need.
Okay. I'm just wondering why you have the flip-flops on. I didn't know if they weren't giving you proper shoes for court. I might have to speak to a deputy or two about that.
Oh yeah, no. All I could scrounge up.
Okay. So what we're gonna do then is we're gonna propose this plea offer from the state here, which would be you will plead guilty to the charge of burglary in the first degree, which again is a felony. You'll plead guilty in exchange for a reduced sentence of 6 months in Bolingbroke Penitentiary. Now, there's a couple things that come along with this that you need to be aware of. Once you plead guilty, you lose all right to appeal this case. Basically, once you plead guilty and accept this offer, there are very limited grounds by which you could challenge this going forward, so you need to be prepared for this decision to be final. Additionally, being convicted of a felony carries some civic disqualifications with it. Most notably, you would no longer be allowed to own, purchase, or receive firearms. Are you aware of that?
Yeah, I am. It's only firearms, correct? It's in regards to like restrictions on weapons. Like if I want a pocket knife for whittling, I could have that.
Well, part of that will come when you get released. You'll be on parole for a bit.
Okay.
Your conditions of parole we can talk about once you get out. I would probably not want you to have any kind of weapon, at least when you first get out.
That's reasonable.
And then, you know, there are additional consequences beyond the legal system. You know, this may come up in the future when you apply for a job, things like that. You're aware of all those potential challenges that may come your way?
I am.
All right. And has anyone promised you anything outside of what you've heard in this courtroom today if you plead guilty?
No.
Okay. I need you to, what we're going to do, we call an allocution here. So I'm going to need you to at least give me, I'm going to read you some of the principal elements of the offense here. And only if these things are true, I want you to tell me if these things happened. I need to make sure that you are aware of everything that you're pleading to before I can reasonably accept a plea of guilty from you.
All right.
So, Mr. Smith, is it true that you entered a house, room, apartment, tenement, shop, warehouse, store, mill, barn, stable, outhouse, or other building on October the 8th, 2024?
Yes.
Mike is doing a
Did you have an
phenomenal
intent
job
to
up
commit
there.
grand or petty
He
larceny
really
or
is.
any other felony when you
I was
entered?
trying to send him all the
No.
information, like you.
Okay, because that's one of the elements of this offense.
I was trying to send him all the things he needs to, like, know what to do.
So if you need a moment
he
to
knows it
speak
all.
with your lawyer, that's fine. But
Wait, what did he
I just
say?
want to make sure you understand. What
Well,
you're
he's saying he didn't do part of what makes it a burglary. Something you can do, Dallas. If you want to chat with him real quick, you can just come back and on his behalf, you can say, and also I can send this to you, but you can say that we stipulate that there is a factual basis for the charge. When you stipulate to a factual basis, you pretty much are waiving this colloquy that the judge is doing to verify all the parts. You're just saying, yep, we agree, totally.
I accidentally pushed the wrong button and fell out of my chair.
Beautiful. sit back down. I have nothing to be standing up for right now.
Careful, that chair's a little janky.
Oh, I know. Luckily, every time I stand up, it puts me on top of the desk. I can just sidestep off of it, but...
Your Honor, after conferring with my client, we stipulate that there is a factual basis for the charges.
So ordered. All right, Mr. Smith, you're aware of the penalty that you'll be accepting in exchange for your plea of guilty here. It'll be 6 months in the state prison. I guess
Yes.
the county jail.
Yeah.
All right.
Would have been dumb to
As
not
to
take
the
that
offense
plea
of
deal.
burglary in the first degree, I do take note of your plea of guilty, and I find your plea to be knowingly, intelligently, voluntarily made, and is free of coercion, threat, or any other influence. I do find you guilty on the charge of burglary in the first degree, and you'll be remanded to the custody of the Los Santos County Sheriff to execute that 6-month jail sentence with 5 days credit for time served so far.
All right.
All right, so that'll clear out this case unless you have anything further or the state has anything further on this matter.
No, I don't believe so. I did have a citation I was looking to plead to today, but
Yes, sir, I
if we
understand.
can-
You just need to make
okay.
sure there's nothing else on this criminal matter first.
Nothing else
Okay.
from the state, Your Honor.
Nothing else from defense, Your Honor.
All right. We'll move on to the traffic offense. Our counsel, are you ready to proceed on that? Mr. Pearson?
Yes, Your Honor. To my knowledge, the defendant intended to just enter a plea to this traffic infraction and receive a fine. That being said, Your Honor, based on his incarceration status, the state would move to have a sentence of discharge imposed. I don't think that he's going to have the ability to pay fines and fees on the traffic case while he's in custody.
Mr. Pearson, could you remind the court what he's charged with in the traffic case?
Yes, Your Honor. One moment. Reference my notes here. I swear, our case management system gets worse and worse every time. I've got that pulled up here. I'm just waiting for it to open. All right. Thank you for your patience, Your Honor. So, in traffic case 0043, defendant is charged with 1 count of lighting equipment to be lighted during darkness. This is on citation 48991, issued by Deputy Morris of the Los Santos County Sheriff's Office.
All right, Mr. Smith, and you wish to plead guilty to this charge too?
No contest.
No contest. All right. And I guess you don't have an attorney at this point, so
No.
would you, acting pro se, would you be willing to stipulate to the offense here?
Please remind me what that means again.
Basically, you're not telling me that you did it, but you're agreeing that if this case went to trial, the state would have enough to prove that you are guilty.
Yeah.
All right, I accept.
Makes
Fine,
twice
and
that
this-
I've had to. He's had to stipulate.
The $250 payable to the clerk of the court. As you're in custody, we can have that handled by the corrections staff. They'll show you how to take care of that. It's just an infraction, and it's a vehicle-related infraction. I don't foresee you driving anytime in the near future,
No.
so I'm not going to impose any requirements or anything with this. It's
So rude.
as a correctable citation. So just once you make it back to driving a car, just be careful. Make sure you turn your lights on.
Yeah, I plan on it.
All right, Mr. Smith, unless you have anything else, that'll conclude our business today. I'll have you taken back into custody and you'll begin serving your sentence for the criminal charge immediately.
Sounds good.
Why is he limping?
Bailiff?
I think he got hurt when he joined the server today.
I feel like that's why Mike asked him, like, are they
Yeah.
treating you well?
Anyone know what his ID is?
Follow me, sir.
I don't know who it is.
Hang on. He is. Oh, I think that's Silas.
Yeah, it's Silas.
He's number 12. He'll start walking better all of a sudden. All right.
He wasn't wanting to take your deal, and I told him, I was like, if you don't take this, I was like,
Fix now.
DA is going to bury you.
Hey, getting the pretrial offers out of the way. I was thinking about probation, and I was like, nah, it's a felony burg with 6 years. Like,
Yeah.
we'll do some time in custody, call it. And just
I told him, I was like, that's probably one of the best deals that you're going to get without having to give someone up or something.
Matt, you represent Pushinsky, right?
I do.
Is he also in custody in the back there?
He should be, yes.
Okay, he's the next
And
case
Mr.
up.
Pearson, looking in the court system, I do see there is still an open search warrant for Mr. Smith. Have we executed that warrant yet?
I don't have that information on hand, Your Honor. So long as that warrant was granted, I'd request the warrant remain open and serviceable during his time in custody for the sheriff deputies to take care of whatever it is that. Well, I rescind that, Your Honor. That warrant can be canceled.
If I may, Your Honor, I believe Deputy Adams did execute that search warrant.
Easy peasy.
He's here today, correct?
Yes, Honor.
Will you just go get him so he can tell me that himself real quick?
Of course.
What are the grounds behind the search warrant? Is it because of... Well, yeah, he... Yeah.
I'd still have that warrant rescinded because he's already pled to it, so we don't need to do it anymore.
No, Corporal Adams.
Oh.
Did I just hear my name?
You did. You didn't put in that warrant.
Go ahead and...
No.
Is there somebody else out here? I'll go ahead and lock the door and...
I did not send him that warrant. Did I?
Deputy Adams, if you want to just stand in the podium in the middle there, I just have a quick question
Yes, sir.
for you here.
Yes, sir.
So I granted you a search warrant on October 8th for James Smith. You were looking for a DNA blood sample from him. Did you execute that warrant?
Yes, that is correct.
Okay, and you filed a copy of the evidence report with the court?
Yes, sir.
All right, we'll close that warrant out. Thank you, Deputy Adams. You can go back to your post.
Yes, sir. Thank you.
Actually, law enforcement that are on duty and acting within the scope of their profession are permitted to wear hats in the courtroom. Or not. I don't know. Hold them in contempt. Fuck them.
Did we not do any traffic today at the start?
I don't think anyone's here for traffic, dude. There's 3 civs in the
All right,
audience.
Next we'll call 0106, Vladimir Pushansky.
Can I head to the desk now?
Yep, you'll come up to the desk. So if you want him to do the colloquy like he was doing with the other guy, ask him if he agrees to all the charges. That's totally fine. Otherwise, you can use that phrase that I put in there that we stipulate that there is a factual basis for the charges, and that should allow him to waive those questionings. There's still some things he has to ask to make sure it's a voluntary, knowing, and intelligent plea. but you can skip the part where he's like, "Did you do this?"
Gotcha.
Especially considering it's a no contest plea. Actually, considering it's no contest, you just waive all that.
All right, Vladimir, you can go ahead and stand by the podium. I'm going to remove your cuffs.
All right, Mr. Brzezinski, we'll get you started in just a minute here. If I can have counsel announce their appearances.
Okay, Dennis.
Yeah, you know.
Thank you, Your Honor. On behalf of the state, Justin Pearson, bar number 239087.
Thank you, Mr. Pearson, and the defense.
Defense Michael Baskin, bar number 241153, Your Honor.
What is my bar number?
Very well. Mr. Brzezinski, I want to remind you of a couple things. I'm sure you've heard this several times by now, but it doesn't hurt to make sure. You have the right to remain silent. Anything you say here can and will be used against you. You have the right to stop at any time and ask to speak with your attorney. You understand?
Yes.
All right, sir. You're charged with violation of section 187 of chapter 1 of the penal code, which is the crime of murder. That is a felony and it carries a maximum penalty of life imprisonment without the possibility of parole. You're also charged with a violation of section 245 chapter 9 of the penal code, which is assault with a deadly weapon other than a firearm. That is also a felony and carries significant penalties. Now, I understand we're here for a status conference. Your attorney has a matter to discuss here. I'll let him address the court here.
Yes, we do.
Or Mr. Pearson.
Your Honor, we are ready to plead no contest.
Mr. Pearson, what's the offer?
Thank you, Judge. In exchange for a plea of no contest in this matter, the state is seeking... Give me one quick second here. In exchange for the plea of no contest to count 1 of murder, Your Honor, we are suggesting that the defendant serve a prison term of 25 years with parole eligibility after 20 years. Further, that his visiting visa be revoked and barred from visa eligibility permanently in the future. And that will come with the the deportation consequences at the conclusion of his prison sentence. As for count 2, the state would motion to dismiss upon accepting that plea offer and sentencing.
All right, Mr. Brzezinski, do you wish to accept that offer from the state?
Yes.
As to the charge of murder, how do you plead, sir?
Guilty.
I believe you're, you don't have to make any particular plea here. I want to hear what you actually think, but I believe your attorney said you were going to plead no contest.
That's correct, Your Honor.
So I'll ask this question again, Mr. Brzezinski. How would you like to plead as to count 1 in this case?
No contest.
No contest. And as to count 2, would you also plead no contest?
The state, Your Honor, pardon me, the state would not ask that he enter a plea to the charge, and just as long as he enters that no contest plea to count 1, we would just motion to dismiss count 2.
All right. Mr. Proshansky, it's alleged that on September the 12th, 2024, you did intentionally and knowingly kill a person, Mr. Robert Local, by intentionally striking him with a motor vehicle, subsequently causing death. That is contrary to the laws, statutes, and ordinances provided for and against the peace and dignity of the County of Los Santos and the State of San Andreas. You understand that there are significant penalties attached to the acceptance of this plea offer.
Yes, I understand.
And are you or your counsel willing to stipulate that the facts alleged in count 1 are true and correct?
We so stipulate, Your Honor.
Very good. Mr. Proshansky, you also understand that as a result of this conviction, which will enter onto your record as a charge of murder, as the district attorney mentioned, you will be found inadmissible to the United States by the federal immigration authorities, and most likely you'll never be able to return to this country following the conclusion of your sentence.
Yes, I understand. I don't want to come back anyways.
All right, and do I understand correctly you're from Russia?
You know, he was arrested that same day
Do you
too
feel
for,
unsafe in your country? You feel
or
that
he
there's
was
a risk of being
detained for
persecuted
theft.
If we were to send you back there?
No.
All right. Alrighty, sir. As to count 1, the charge of murder, I do find you guilty. I will impose the sentence requested by the state. You'll spend 20 years in the state penitentiary, at which point you'll be eligible to be evaluated for the possibility of parole. As to count 2, assault with a deadly weapon other than a motor vehicle, I will dismiss the count as part of your plea arrangement with the state here. I apologize, 25 years in the state penitentiary. We'll correct that on the record. You understand all that, sir? You still want to continue?
Yes, yes, sir.
You understand you're giving up your rights to an appeal if you do proceed?
Yes.
And has anyone coerced you, made promises, offered to do anything outside of this courtroom to influence your decision to make this guilty plea, or excuse me, no contest plea?
No, sir.
All right. I do find your plea knowingly, intelligently, voluntarily made without threat of coercion or promise. I do find you guilty of the charge of murder, and you are remanded to the county, or to the state of San Andreas Corrections to begin the execution of your sentence.
They said continue towards
Your
execution. I
execution.
was like,
Sweet.
Mr. Pearson, Mr. Defense Attorney, you have anything further?
Nothing,
No, Your Honor.
Nothing further from the state, Your Honor. Thank you.
All right, bailiff, take to Mr. Proshansky into custody.
I might have to request a recess to give him time to swap over if I'm on the docket next. Yeah, that's him. I might say he got hung up in a meeting with his probation officer or something, so I was in contact with him.
Yeah, totally fine. A couple other cases on, I believe.
Because he has to run all the way around to get changed
Right,
and through.
right.
All right, next we'll hear the probation violation case 0124 for Mr. Jose de la Cruz.
Your Honor, on behalf of De La Cruz, I am his defense attorney. I was just in contact with him. He has been held up in a meeting with his probation officer. May I request a recess to give him time to get in?
Yeah, that's fine. We'll push that one off.
Thank you, Your Honor.
My guy, I apologize.
You're good. Just hop in whenever you can. I'm gonna see if we can handle something. Oh no, wait, did Silas already leave? Oh,
Yep.
No, hang on. There's
Silas already did leave.
no. There's a case. It's State v Silas. It's not actually Silas. It's someone whose
All right,
last name
we'll
is
go
Silas.
on to some traffic for now.
Aha, that's me.
Case 0040, Joseph A.
It's a traffic ticket.
Yeah.
Dennis.
Yeah, it is. But it's against Mr. Silas, who he's here. We're good.
Dennis.
What?
Mr. Bender,
Hello?
could you state your name for the record, please, sir?
Can you not hear me?
Joseph A. Bender.
Mr. Bender, do you have an attorney with you today?
Wi-Fi.
Dallas, can you hear me?
No, I do not.
Okay.
Okay, because it's a traffic case, you don't have the right to an appointed lawyer. So are you comfortable proceeding here on your own?
Yeah, the last name Silas. That's
Yes.
it's a traffic ticket.
Yeah, that's correct.
That
He's-
is, yeah. That's,
Yeah, he's on right now.
All right, so it looks like you're charged with unsafe speed for prevailing conditions, 1 to 15 miles over the limit. This was charged July 6th of this year. It's alleged you were driving 46 and a 35 while operating a commercial motor vehicle. This carries a DMV point and a fine of $250 for the violation of Section 22350 of the San Andreas Vehicle Code. How would you like to proceed, sir?
It must be. We're good. I figured it out.
With the
Would you like to contest the ticket? Are you just here to make arrangements? What would you like to do?
resolve it.
Okay. Are you looking to admit responsibility here, pay the fine? Are you proposing something else? What would you like to do?
Pay the fine.
Okay. Have you had a chance to go to any defensive driving school, any online classes for speeding, the resources that we provide through the
Zach?
court clerk?
No, I haven't had a chance to do that.
Okay, so you understand that by agreeing to resolve the case by paying the fine, you're also subject to the DMV point being added to your driving history.
Yes.
Okay.
Zach just messaged me asking if I'd like to represent him for the
I will
trespass for
find you
Mr. Nelson.
guilty and as to the charge of unsafe speed for
So,
prevailing
I-
conditions. The fine is $250.
It's in a ticket.
One
It's
of the
not.
Yeah,
It's not yet.
one of the
It's not gonna
deputies
make
in the
it
court
on
here
today's
will
docket,
help you
but
get that
if he
paid. on
needs
your
No,
own.
it'll be
Okay.
for the next one.
No, he's just looking
Alrighty,
for
sir, thank you.
representation on it. That's
Yeah,
why he
then-
messaged me.
Yeah, then I don't. Yeah, I think you should be good for that. I'm trying to make sure no one gets super overloaded with cases, but I think you've got plenty of room. I missed the outcome of that traffic ticket.
They gave him the fine.
Oh yeah.
7-8, if you could just help that gentleman in the lobby get his ticket paid.
Alrighty.
Hey man, you need get a ticket paid. All right, man. Just 1 second.
Thank you very much, Astro. Looking forward to seeing you in court here sooner than later. Remember, if you need to open a court case, head over to the SLRP Discord, go to Courthouse. You can open a traffic, criminal, or civil case. If you have any questions at all, please feel free to reach out to me. I take part in both sides of the law here, and I can give you totally impartial advice and help you out getting that case filed and getting you in for court.
All right, man. You're good to go.
Okay, do we have any other traffic cases that we need to hear?
What's your name? Yep, what's up? Got it.
Is that Mr. Delacruz that just came into the court there?
Yes.
All right, Mr. Dela Cruz, if you'd like to come forward, we'll handle your case here. All right, Mr. Dela Cruz, I'm gonna have your attorneys or your attorney and the state's counsel announce themselves, and then we'll get you started. Okay.
Okay.
Mr. Pearson.
Thank you, Your Honor. On behalf of the state, Justin Pearson, bar number 239087.
On behalf of the defense, William Stewart, bar number 241053.
Thank you, gentlemen. All right, Mr. Dela Cruz, this is a probation violation hearing. What that means is we are not looking to adjudicate questions of guilt or innocence. You've already been convicted. This is merely determining whether the allegations that are presented against you are true or not true. I'm going to let the state proceed first here because they're the ones alleging a violation of your probation, okay?
Okay.
Why is there someone in front of me in court, bro?
Thank you, Your Honor. Again, allow me 1 second to review this case file so I can give you a little bit of information on it. I will say there is a stipulated resolution on behalf, or pardon me, before the court today. I can tell you that resolution is, so long as defense still wants to admit to the probation violation, my recommendation is to sanction the defendant by issuing him an 8-hour community service order to be due within 8 weeks. And I will just grab the information on this case real quick here to let you know exactly what the basis of the show cause is.
And just generally speaking, I understand this is for a take vehicle without consent charge.
Yeah,
Is that right?
That is correct, Your Honor. So the allegations as the defendant stands here both stem from September 21st of 2024. The first one is that a portion of the defendant's probation is to be in his residence between the hours of 1800 and 07, so 6 p.m. and 7 a.m., and he has a probation officer that checks on that.
The case wasn't called yet. Where I need to step in, right?
It alleges that he was outside of his residence at that time based on a police report filed by Deputy Brendan Morris. The second allegation, alleging from the same date, is that the defendant was arrested by Corporal Austin Bradley for failure to appear at a mandatory check-in with said probation officer. This check-in was at 1900 hours, and he was not at his residence at this time. So both of these allegations kind of go hand in hand. He wasn't where he needed to be and was contacted by law enforcement after those hours. At the request of his probation officer, he was taken into custody and charged with the probation violation. So, all things considered, it's not the most major thing here. He's charged with a probation violation, but he's not charged with new crimes. He's not out there stealing new cars. He's not breaking and entering, so on and so forth. So this is pretty insignificant, but it is a violation of probation. So again, my recommendation: have the defendants complete 8 hours of community service, have a due date 8 weeks from today, have him give a little bit back to the community, and then just continue his probation. No need to extend it or terminate it now. Just let it continue on to the natural expiration.
And Mr. Pearson, does this gentleman have a GPS monitor?
There is not one ordered at this time, Your Honor. The state is not asking for it, but of course, Your Honor reserves all rights to do so.
All right. We'll hear from defense counsel.
Your Honor, we have no disagreement with the plea offer that is at hand. We have been in contact with Mr. Pearson in a joint meeting prior to discuss the engagement around it, and we still would like to move forward with the plea offer as of right now.
And how would you feel if I ordered your client to wear a GPS tether?
With it being an add-on to the plea, I would like to refer and speak with my client to make sure that he would still like to move forward on my behalf. I wouldn't have any disagreement with it.
Mr. Dela Cruz, would you like a moment to speak with your lawyer?
Yeah.
Okay, counsel, I'll just let you know too that I intend on the other condition I intend on imposing here will be a drug test when he comes back in 8 weeks.
Yes, Your Honor.
If you'd like to speak with him, you may go ahead.
Huh?
I seemingly cannot unmute myself in Discord now.
Yes.
Oh, wonderful. It was not letting me unmute myself.
Um.
Your case, Valerian. Remind me what case it is.
I've got two. I've got my traffic ticket one, which I'll just need to step out real quick and swap characters.
That's right, because you are Mr. Silas, right?
I am.
Okay,
yes, but that one's a pro se counsel, so that I do myself. And then I've got this one for Steve, where I'm the stand-in lawyer.
And that is 0098, right?
I believe so.
For
2
Mr.
seconds to
Williams.
confirm. Give me 2 seconds to confirm. but I
Yes, that
believe
is
so,
that
yeah.
is the one. Okay.
The amended.
Yeah, the plea offer is good. It's just
Let me look at the new amended plea offer because I didn't see it.
it just allows him to plead no contest instead of guilty.
Okay.
Same plea offer otherwise. So what you'll need to do,
Your Honor, may
hang on,
me
we'll
and
talk about
the state approach to discuss privately with you.
Yes. We'll have a sidebar. Bailiff, turn on the noise generator that we totally have.
After speaking with my client, he requests that due to the changes that are made of the tracker and the drug test, he requests that at least 15 minutes be knocked off of his probation or his community service.
So
He wants to do 7 hours and 45 minutes.
So I'm not willing to do that, and here's why. Monitoring law enforcement reports as they come through. This gentleman's been contacted multiple times outside, or pardon me, not outside, but aside from like today's case, right? He's been contacted numerous times by law enforcement for traffic violations. So part of his probation is to also stay out of trouble. And it's very rare that I would ever show cause somebody for a traffic infraction, but he's out there racking up traffic stops with law enforcement. He's not staying out of trouble. Frankly, if he doesn't want to go with that 8 hours community service, I have no problem pulling my plea offer, or pardon me, my PV offer right now. We can set this for a contested hearing. I'll recommend revocation. He can go sit in jail for a couple months.
Speak to my client.
All right.
All right, Your Honor. After discussing with my client, he he agrees to all mandates and changes that have been placed, along with the 8 hours of community service that was before talked about with Mr. Pearson.
All right. Mr. Delacruz, as to count 1, that's alleging that you violated the conditions of your probation and that you were outside of your residence during times you were ordered to be there. You I'm going to ask you whether count 1 as alleged by the state is true or not true.
It's true.
All right, I find you having violated your probation. As to the sanctions, we'll accept the recommendation from the state. You are to perform 8 hours of community service. You are required to return here 8 weeks from today at the next court date following that and present proof that you completed the community service work. It can be done with any not-for-profit organization. There's no specific charity or cause that I need you to go do that for. You understand?
Yeah.
If you don't do that, I'm going to put a warrant out for you, and you're going to end up sitting in jail when there's no reason to. Additionally, you have some conditions. Some of them are carried over from what you already had on your probation. Those will all remain in effect. And then just to reinforce it with you, there's a couple more conditions here. You are not to commit any further crimes. You're not to possess or use drugs. That's anything that you're not prescribed, which is important because marijuana is legal in this state, but I am imposing a condition of your probation that requires you not to consume marijuana, not to smoke it, not to eat it, not to do anything with it, unless you have a medical marijuana card registered with the state from a physician. You understand?
Yes, sir.
Additionally, I'm going to impose that GPS tether. So you're going to get with pretrial services once you get out of here, and you're going to get that installed before you leave today. That is going to monitor your location 24 hours a day. You're required to charge it. If it runs out of battery, you're going to end up before me, and I'm not going to be happy, okay?
Oh, okay.
So if there's any reason that you need to be out of your house when you're not supposed to be, you need to make sure you clear that with your PO first. Otherwise, you're going to end up in violation, okay?
Oh, okay.
So that's the sanction I'm going to impose. Those are the conditions. Do you have any questions for me, sir?
No. Or wait, maybe. What kind of charger do I need for the GPS? I don't want it to die.
They will provide it for you. You'll just have to pay the fees. I'm not entirely sure what the fees are for the equipment, but the pretrial services people will take care of that with you.
Okay.
So you'll get I believe you'll get a backup battery plus the one that they put in there. And just remember, when you're changing the battery, you got to stay plugged into the wall. Otherwise, it'll turn off and it'll report a violation to us.
Oh, okay.
So I'm going to set your case over, and we're going to revisit this in 8 weeks. If you come back to me and you take a drug test and it's positive for something that you don't have a medical excuse for, if I get an alert about you leaving your residence or violating any of the other conditions of probation, we're going to have a very different conversation. If you do all that stuff, then your probation will terminate once I see proof that you completed your community service at the end of those 8 weeks. All right?
Oh, okay.
All right, Mr. Delacruz, keep your nose out of trouble here, and we'll see you in 2 months.
Oh, okay.
All right, sir.
Which way do I go? This way?
Yep.
Oh.
All
Yeah,
right.
that's
Are there
fine.
any other cases that we need to hear today?
Yes, Your Honor, to my knowledge, there's going to be at least 2 more cases on the docket. If we could call State versus Williams, case 0098.
Is that where I stepped my ass on? Ooh.
Okay, it looks like we had a little clerical error there. It should be Smith, not Williams. Is that the case we're looking at?
Your Honor, it is. I apologize.
No worries. Looks like my clerk screwed that up. All right, we'll call 0098, State of San Andreas versus Devontae Smith.
That's where I walk up.
Hi. Mr. Pearson, is the defendant in custody?
Your Honor, to my knowledge, yes, the defendant is in custody. I believe defense counsel intends to waive his appearance today.
All right. Go ahead with your appearances then.
Thank you, Your Honor. Continuing to appear on behalf of the state, Justin Pearson, bar number 239087.
And the defense.
Arnold Lewandowski, bond number 241204.
All right, gentlemen. Mr. Pearson, how would you like to proceed here?
Your Honor, I have no objection to waiving defendant's appearance. It looks like there is a no contest plea petition filed in the case. I have no problems allowing defense to enter said plea. My records indicate that the defendant will be entering a no contest plea to count 1 carjacking, be serving an 18-month sentence with Department of Corrections, and then similar to the previous case, I'll be moving to dismiss counts 2 and 3.
And Mr. Pearson, you said count 1 is carjacking. What are counts 2 and 3?
Of course, Your Honor, that is useful information. Pardon me, I'll just double check my case file. Count 2 is making criminal threats, charged as a misdemeanor. And count 3 is providing false identification to a peace officer, also a misdemeanor.
All right. I think Mr. Lewandowski just had a quick word with the aliens here, so we'll give him a minute.
Very understandable. They are a demanding folk.
Oh, yes.
I know.
The aliens' comments made me laugh so hard.
What happened? Yeah, with this
Okay,
computer
speak
they
to my
are.
client.
Fuck.
We will just
Sorry, my wife got
casually look the other way as you pop back in as someone not you.
My computer, sometimes there are days where I want to grab it and throw it out the window.
Oh yeah, no.
At a very fast speed. And then I remember this is a really expensive computer. So I probably shouldn't do that.
Did you catch everything we said about the charges and what have you? Or did you miss any of it?
Caught up to the no contest of count 1.
Okay, I will restate the whole thing for you.
Just a second.
All right. Your Honor, just for defense counsel's, just as a courtesy, I'll restate that count 1 is a felony carjacking, count 2 is criminal threats as a misdemeanor, and count 3 is providing false ID to a peace officer as a misdemeanor.
All right, Mr. Lewandowski, back with us, sir?
Yes, Your Honor, I apologize.
Not a worry. I know the aliens are a bit rude at times. Are you willing to waive your defendant or your client's appearance in person today?
Yes, John, I am.
Okay, and you understand the plea offer that's on the table from the state that count 1, the charge of carjacking, would result in an 18-month county jail sentence, and counts 2 and 3 would be dismissed.
Yes, Your Honor.
And you've had a chance to confer with your client about this?
Yes.
Sorry, Mr. Lewandowski, I didn't hear you.
Okay. Yes, sorry, Your Honor, I had to recount in my head real quick. And I did, yes.
All right, and you've gotten a copy of the waiver of rights form to him. He's okay with that. He's signed off.
Yes, he has, Your Honor.
All right, then on behalf of your client, how does he plead?
No contest.
Correct.
Your Honor, he pleads no contest.
All right, based on your representations, I will accept the plea. I will find Mr. Smith guilty of the crime of carjacking. And as to counts 2 and 3, those will be dismissed. For count 1, the defendant will serve 18 months in the county jail. As to post-release matters, we can address those at a later hearing if you would like to.
What is that emo, Dennis?
Does the state have anything further for Mr. Smith or his counsel here?
No, Your Honor. State has nothing further at this time.
All right, and if my information is correct, he's already in the custody of the Los Santos County Sheriff, so he is further remanded there for the immediate beginning of his 18-month sentence. That's all, gentlemen. We can move on to the next case. Thank you.
Bruh, I've been in jail
Thank you,
since
Judge.
like July.
Your Honor, did you want to address any credit for time served on that matter?
Why are you sitting up there and not up here?
We certainly can. How long has he been in custody for?
My records indicate, Your Honor, he's been in custody since July. I believe he's accumulated roughly 3 months of credit.
Because I have another case where I'm pro se. When he asks me, or okay. Your Honor, we're asking for him to have that credit.
Okay. Does he, we have any reports of him causing issues in the jail, anything like that?
No.
I have nothing on my record, Your Honor. It seems he's been a model inmate thus far.
Val, are you representing yourself?
In my traffic ticket, yes.
All right. I'm going to give him time served credit of 6 months because I always appreciate when people can take their sentence without causing problems for our lovely jail staff. The defendant, as I mentioned, is guilty on count 1 carjacking. He will serve 18 months in the county jail with a time served credit of 6 months. Anything else?
Thank you all. Thank you, Your Honor.
Nothing further from the state.
All right.
I've never been in court. I just want to make that clear.
0098 closed out then. We'll revisit that in 12 months or so.
Thank you, Judge. I believe we have 2 cases left to call. There is a traffic case 004. I believe defendant is pro se in that matter. I do believe it's against Lieutenant Mike Simon. I'm not sure his whereabouts at this point in time. And then there are oral arguments needing to be made on 0040.
Yep.
Marcos v. Los Santos County.
All right. As to the traffic case, I will have to speak to Lieutenant Simon's superior and see why he's not in my courtroom, but we'll deal with that at a later date.
It's going to be a hell of a self-conversation.
I will call 0040 civil case Jerry Marcos versus the County of Los Santos.
Should I change into my other character? Why no? But because I. Okay. Okay. So then, should I sit up there? With
All right,
the
Mr.
other ones?
Pearson's here on behalf of Los Santos County. The plaintiff is represented by.
Robert S. Zimmerman, Your Honor. Bar number 241207.
All right, Mr. Zimmerman. Where is the is your Mr. Marcos? Is Jerry Marcos family member of Larry Marcos?
That is correct, Your Honor. Jerry Marcos is the brother of Larry Marcos, the one that is deceased.
And make sure you're on shout if you're not.
All right, and Mr. Marcos doesn't wish to appear here in person.
That is correct, Your Honor. We're just filing a motion to quash the objection of the plea or the subpoena that we are issuing for the LSSO body cam footage.
All right, so we'll hear the motion to quash today. You can address the court first, Mr. Zimmerman. Or,
All right,
excuse me, Mr. Pearson, because he's trying to quash it.
Fair enough.
Oh.
Thank you, Your Honor.
Having a hard time there, dude.
Thank you, Your Honor. Appearing on behalf of the state in this matter as defense, as it so happens, Justin Pearson, 239087. My office was served with a subpoena back on the 8th of October for Los Santos County Sheriff's Office body camera, dash camera, and all sorts of reports related to an outstanding lawsuit. Pardon me, let me approach this podium. All of that pertaining to an outstanding lawsuit that alleges misconduct by the Los Santos County Fire Department. What you have here is completely separate entities, Your Honor. The Sheriff's Office and the Fire Department, they may have both been on scene here, but trying to obtain all this additional documentation footage from the Sheriff's Office is entirely irrelevant to the outstanding claim against the Fire Department. All that it does is cause further issues for us to actually provide them with the relevant discovery. What they're doing is they're trying to find a way to bury us in paperwork and not allow us to present discovery on time. We have no problem with the originally filed subpoena for the Fire Department records, but going forward to provide them with the Sheriff's Office records, it's not worth our time. They don't need it. And so that is why I'm in front of you today. I would like to ask that you quash that subpoena, not require the state to present that.
All right, Mr. Zimmerman, we'll hear from you.
Thank you, Your Honor. So the reason why I'm requesting the subpoena and that I object to the quashing of the said subpoena is because at this time we still don't have the body cam footage from the LSFD along with the SOGs, and that's totally fine. I'm okay with that. It's the fact that I want to see if Mr. Larry Marcos was attended to by the said LSSO officers on scene, and whether or not we can actually have a visual evidence of this, of any said paramedic, whether it be supervisor or anybody on scene that has done any of the life-saving measures for said deceased victim.
So, Mr. Zimmerman, help me understand a couple things here. Your client is, the original client at least, is deceased, correct?
That is correct, Your Honor. And Mr. Jerry Marcos is suing the LSFD
Discord keeps
for,
fucking not letting me unmute my damn mic.
negligence of death and malpractice, I believe.
All right, so just for the record, then, your client is not facing any kind of criminal prosecution, as it would be fruitless because he is deceased.
That is correct, Your Honor.
So tell me this, why do you need the sheriff's office
There's the
body
crash I was waiting
cameras
for.
if you've already got access to what fire department's got?
It's in the event that we don't have access to the LSFD body cam footage or vehicle cam footage at that time, Your Honor. I also wanted to see if there was any anywhere that was stated about the injuries that Mr. Larry Marcos had suffered from the LSSO officer on scene at that time. And it's more so just for the body cam footage, just to see if there was any life-saving measures that were taken from the body cam footage, whether it be from the actual person that was saving the person or video evidence of any of the the LSFD doing any CPR measures before Mr. Marcos had died at the
Valerian,
hospital.
I'm seeing if there's a way to get another judge available for your case.
All
Just
right.
kinda
I see we have a member of the fire
stand
department
by.
in the courtroom. Are you planning on calling him for anything?
Not at this time, Your Honor. We are not filing for a deposition or anything like that right now, as this is still in the preliminary investigations on behalf of Jerry Marcos for the deceased of, or for the estate of Larry Marcos.
All right. And how would you respond to the state's proposition there that you have everything you need from the fire department's records and camera footage?
At this time, Your Honor, we don't have any of the records from the LSFD. We don't have the standard of operating guidelines or the body cam footage, and that is why I'm requesting the LSSO body cam footage. I only need just for that scene. I don't really necessarily need the reports of.
Your Honor, the state wants to make an objection.
On what grounds?
The way that the plaintiff's counsel is making it sound is that we've somehow failed to present them with the requested fire department body camera, dash camera, etc., SOGs in a reasonable time. However, their subpoena is not until November the 1st. That's our deadline. So his statements are as if we haven't provided him in a timely manner. We're still within that timely manner that they've asked for. So,
Your Honor, I'd also like to clarify that I also did state that they have not, that we have not met the deadline yet, in previous of what my statement had already said previously.
Okay, so I'm going to sustain that objection. We're going to make a note that the deadline hasn't come up yet. Mr. Zimmerman, what it sounds like you're going to want from me is a motion to compel production of the evidence in that subpoena. It doesn't sound like going through the sheriff's office has much relevance on the claims, given the medical records and the fire department's camera footage and guidelines would be more sort of up the alley of your inquiry here. I don't hear any claim being made against the sheriff's office or any reason why their camera footage should be any more of evidentiary value than, you know, the direct footage from the fire department. Do you have any kind of a response to that?
Your Honor, the only reason why I'm asking just for the LSSO body cam footage is for the simple fact that in the off chance that the LSFD does not have body cam footage, I would like to at least see if there was any other body cam footage of the paramedic, whether they were doing CPR or non-CPR related stuff to the pre-deceased at that time.
And remind me again, where did this happen at? It was in an establishment, like a business, correct?
I believe so, Your Honor. I'm just going to take a quick look at my notes here.
Because what I'm wondering is if you've gone through the other resources available to you, like the surveillance cameras of that establishment, in the hospital, anything like that. I don't know if he was transported to the hospital, but I believe the ambulances have cameras in them too.
Yeah, he was transported to the Pillbox Memorial Hospital there in Los Santos, Your Honor. I did talk to Nurse Nancy as well, and she did state that the victim was already has been deceased when Mr. Larry Marcos had died at that time. I also had been told a few other things that I won't really necessarily say because it's not really relevant to this part of the case right now. But yes, Mr. Marcos was shot at the Tequila La, and that's where I just wanted to see the body cam footage from the LSSO at that time.
Okay. So at this time, Mr. Zimmerman, I don't believe you've met the burden of where we would need to be for me to authorize or to excuse me, I phrased that wrong. Mr. Pearson has met his burden in that I believe that the subpoena should be quashed at this point. Now, I do want to let you know that that doesn't mean I'm saying you can never get this. But just given the relevancy concerns, I'm going to ask you to try to get your first subpoena carried out.
All right,
Get the records that way, and then come back to me if either the fire department doesn't get you what you need, the state doesn't
That's
get
fine.
you
Then
help
should I
getting
step
that
out,
information,
change
or you
characters?
get all that and you still believe that there's more relevant info out there.
That is totally fine, Your Honor. I definitely have no objections to that. That is totally fine. I will accept that, Your Honor.
All right, Mr. Zimmerman. So the subpoena at this time is quashed.
Brody's just casually standing at the door.
Keep in touch with me. Keep in touch with the state on the, or excuse me, with the defense counsel for the county here on
No,
your subpoena
at
for
the
the
other
fire
door.
department's
Front door.
documents and records.
Very front door.
And
The one who
we'll see
searches
each
you.
other here
Yep.
probably right after November 1st if you don't have everything you need by then.
That's perfectly fine, Your Honor. Thank you so much.
All right. Thank you, gentlemen. Alrighty. I believe that's all the cases we have for the moment.
All right, guys, I gotta jump out. Thank you, everyone.
So what we're going to do here is we're going to bring in a judge from the local clerk's office here. Just offered to help me out. I got a golf reservation I got to get to. So the court will be in recess for just a few moments here, and then Judge What's-His-Face will be in here in a minute. I got to get to my tea time.
We'll get you whatever we can get you as soon as we can. Appreciate you taking the time to come in today.
Yeah, no worries. Good job out there. I mean, either way, no, it's good.
Same to you. Good to see you again. All right, we'll chat with the judge for a few. Hey, my keycard works in here. Let's see who I'm going to use.
I just added a little note in the case file. Dennis just saying that it was carried out and that proper documents will be handed over to the court for proof of completion of the ground set by the PV offer.
Oh my god, I look like Steven. Alright, this will be the guy. Give me 1 second to duplicate him.
It's shirt overlay 528.
$5.28. Alright, cool.
I've got my character. Just give me 1 second, and I'll be back at the courthouse.
And you are representing yourself in this one, right?
Yeah, because it's a traffic ticket, so.
Okay.
And it's basically just to waive the fact that yeah. You'll learn all about it.
Okay. The name is Lars Jenkins.
That ain't like party.
You guys ready for me?
Ready.
All right.
All rise. The San Andreas Superior Court is now back in session. The Honorable Lars Jenkins presiding.
Thank you, everybody. You may be seated. All right, we have one case left on the docket. I'm calling San Andreas versus Silas. This is traffic case 0044. Is there a Charlie Silas in the courtroom?
Yes, Your Honor, there is.
Thank you, sir. You may have a seat there at that table. Do I have Lieutenant Mike Simon for the state?
Yes, Your Honor.
Thank you, Lieutenant Simon. Mr. Silas, you're here today for a trial. This is a bench trial. It's a traffic ticket. The preponderance of evidence here is, pardon me. The standard of proof here is preponderance of the evidence. So all that this deputy needs to prove is that it's more likely than not that you committed the infraction. And I will pull up your case here to find out exactly what the infraction is. Are you ready to proceed to trial today, Mr. Silas?
Yes, Your Honor.
All right. Do you have any witnesses or exhibits that you intended to present at trial without telling me what they are?
No, Your Honor.
All right. It appears that this charge is an unsafe speed for prevailing conditions, 16 to 25 over the speed limit. Lieutenant Simon, are you prepared to proceed with this trial?
Yes, Your Honor.
Thank you. The state has the burden of proof and therefore will be allowed to go first. Lieutenant Simon, you may present your case.
Good evening, Your Honor. Lieutenant Mike Simon, Los Santos County Sheriff's Office. Badge number is 38. So on September 26, 2024, that's a Thursday, at approximately 16:45 hours, I was on duty as the watch commander for the Sheriff's Office here in Los Santos County. While driving on Route, originally on Panorama Drive, but then ended up on Route 68 in the area of 3045, I did stop a vehicle, a ice white Bravado Buffalo EVX with the San Andreas registration Crackle, which I know to be the name of a electronics company here in the area. I did observe the vehicle on my in-vehicle radar system at 65 miles per hour down Panorama Drive in a posted 35 mile per hour zone. When I approached the vehicle, I spoke with the occupant of the vehicle, who was actually not in the driver's seat at the time of the stop, a Mr. Silas, who is present in the courtroom here. He did advise me that he worked for the Crapple company and that he was engaged in some beta testing of a new potentially self-driving vehicle. I believe autonomous steering assist was the term he used, or something along that line. I did identify him via his San Andreas driver's license, and there were no other occupants of the vehicle. While I was speaking with Mr. Silas, a representative from the call center for Crapple came on the line through the car's speaker system. I was not able to definitively identify that individual, but they did make representations that they were working for the operations team at Crapple. When I spoke with Mr. Silas about what happened, he did admit to me that he had been in the vehicle. I asked him how the vehicle was operated, and he advised me there were some software systems and AI that was being used. However, I did ask him, and he did tell me that the vehicle was going places that he told it to. He did acknowledge that there had been some issues with the safety software, I believe, that was causing some violations of speed limits and a couple other incidents that had occurred with the company's vehicles. I did verify that the vehicle was properly registered and insured. However, given the speed violation and the fact that Mr. Silas, by virtue of being able to tell the car where it should go, under our current state vehicle code, I do believe that puts him in actual physical control of the vehicle. And so for that reason, I charged him with a violation of section 22-350 of the vehicle code.
Thank you, Lieutenant Simon. Is there anything else you wish to say at this time?
I would just draw the court's attention to not only 22-350 in the vehicle code, but also section 305 of the vehicle code, which defines a driver of a vehicle as a person who drives or is in actual physical control of the vehicle. And I wouldn't have anything further for you, Judge.
Thank you, Lieutenant Simon. You may be seated.
Thanks, sir.
Mr. Silas, it is now your opportunity. The first part of your side of this case is cross-examination. Do you have any questions to direct at Lieutenant Simon regarding the testimony that he presented?
No, Your Honor.
Thank you, sir. Now is your opportunity to provide testimony. This is your opportunity to do exactly what Lieutenant Simon did. You can tell me anything that you think I need to know regarding this case. Present your case. However, you have no legal obligation to. The burden is solely on the state to prove the elements of this infraction. If you wish to make statements, now is your chance.
Thank you, Your Honor. I will start off by saying that I was in the vehicle as the passenger, and I was told afterwards that I was basically the person that would be under any infractions should they happen with law enforcement afterwards. Meaning, if we were pulled over, in this case, pulled over for speeding, I would be the person receiving the ticket. That was not made aware to me until after the justice had been done of the ticket. But other than that, I would like the court to know that the Crapple car service is still a very beta, it's still in its very beta testing phase, and it had not memorized the speed limits of the Sandy Shores roads, and it had not obtained that into its database. And that was what we were doing. We were putting it to the test of getting it into its database. And it was just an unfortunate set of circumstances that there was a law enforcement officer on the road catching the Crapple vehicle speeding.
Thank you, sir. Is there anything else you'd like to add?
No, I do not think so, Your Honor.
All right. Lieutenant Simon, I do have one follow-up question for you related to this matter.
Yes, Your Honor.
In what seat did you find the defendant sitting in the vehicle?
Your Honor, he was in the passenger seat, but as he demonstrated to me, he is able to control the vehicle using voice commands from that seat.
Okay. So, Mr. Silas, I have a few questions for you then. There is a high likelihood that this is the first time any case like this has ever been before a judge in the state of San Andreas. So this could set legal precedent. I want to make sure that I have all the facts as they truly are. Is it true that you were sitting in the passenger seat, not directly in the driver's seat of the vehicle?
Yes, sir.
And to what level of control did you have over the vehicle? It sounds like Lieutenant Simon made a statement about something that you said, but explain to me what control you had over this vehicle.
Other than using vocal commands, oral commands, I have no control of the vehicle. I cannot step into the actual driver's seat of the vehicle. and there's no way to maintain an actual control of the vehicle. So the only way I can actually command it is through oral commands.
Did you realize at the time that that the vehicle was traveling in excess of the speed limit?
I did, and I did make several attempts with oral commands to slow down and to reduce speed to the posted speed limit, which according to the onboard GPS system was, and the lieutenant can correct me if I'm wrong, but I believe it was 35.
That's correct.
The notes that I have indicate that's what the lieutenant testified to.
Okay, yeah, so then I did make several attempts to get it to reduce its speed down to the registered speed limit on the onboard GPS.
Thank you, Mr. Silas. Do you have anything else for me at this time?
No, Your Honor, I do not.
Thank you. You may be seated back at the table. Lieutenant Simon, do you have any closing statements?
Your Honor, I'd just like to refer back to the phrase articulated in Section 305, the driver being in actual physical control of the vehicle. I would put forth that Mr. Silas here was, in fact, in actual physical control of the vehicle, as he was able to tell it where to go. And he was the only person in the vehicle at the time that it was being operated on the roads of this state.
Thank you, sir. Mr. Silas, any closing statements from you, sir?
I just have. Give me just one second. I just have the one to state that I was technically not in, quote, I would not class my control, quote, as physical. I would class it more closely as to just verbal and oral.
Thank you, sir. And the state always has the right to the last word, as it is their burden of proof. Lieutenant Simon, you have the right to a rebuttal statement before I conclude accepting testimony. Do you have anything for rebuttal?
No further, Your Honor.
Thank you, gentlemen. If you allow me a couple of moments, I'm going to need to research this case. Thank you, gentlemen. I'm ready to make my ruling. Based on the testimony and evidence that I have before me, along with my independent research regarding this case, I will find the defendant not guilty of the infraction. San Andreas Assembly Bill 1777 is currently going through the process in the process in the House and the Senate to close the gap on these autonomous driving vehicles and how to hold the representatives accountable. Unfortunately, with no laws in place, I cannot find that Mr. Silas was in violation of the speed limit, because he was not in what I would consider control of the vehicle as stated under San Andreas Vehicle Code 305. I do not find Mr. Silas to be the driver. I will have this citation dismissed. That being said, the state is always welcome to file a notice of non-compliance with the vehicle's company in and of itself and take that company up on civil charges. Any questions from either of the parties?
No, Your Honor.
No, Your Honor.
Thank you very much, gentlemen. You're excused. If that is all the matters on the docket today, court will be adjourned. Thank you, Deputy. Oh my God, how did you... Good God.
Hello. Thanks for filling in. My tea times are crazy.
Oh, I believe it. Is there anything else on the docket today?
I don't think so.
I didn't think so either.
Thank you. No, thank you. I'm positive.
There was some on-the-spot research needed for that, and that is a really relevant thing happening right now.
Bullshit, 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 bullshit.
I don't know about all that. Contempt.
He fucked this up. Even he agreed. He's like, I wouldn't classify it as physical control, but I was in verbal and oral control. And it's like...
So the research that the other judge did, though, is there is an outstanding assembly bill that tries to shore up that law, but as of right now, it's not shored up. And because he couldn't actually physically hit the brakes, that's what the judge decided. You know, the state's welcome. The state can always file an appeal. But the state can also serve that notice of non-compliance to that company and say your vehicles aren't working right. That can lead that whole company to getting shut down.
They would need an override. Like, realistically, you would need an override.
Oh, yeah, 100%. That was...
In all of those cars that I've ever seen, even if it has like a Waymo
even
or whatever
Tesla.
where it drives itself, you could still go
Yeah,
the brake pedal or
even
emergency
Tesla, like you
stop
have to
button.
keep your hands on the wheel at all times.
Well, this was an allegedly completely autonomous vehicle where that person was sitting in the passenger seat.
Also, the car was making fun of him a lot.
That's something. I mean, you got pulled over for speeding in a vehicle that shouldn't be able to speed. I'd make fun of him too.
Yeah, it was calling him all kinds of names. It was interesting.
Good court sesh.
Yeah, absolutely. Lots of stuff to work on for next time, and that went fantastic though.
I fucking
Yeah, that was fun.
When I was talking with my client, he's like, "Well, can they like lower it?" I was kind of stunned there for a second. He even messaged me. He's like, "I know I stunned you."